Warm welcome to everyone to ADB's Climate Risk webinar. I am Christina Pack, your moderator for the event. We are extremely grateful for your interest in this topic, and thank you for joining us today. It's 3 p.m. We're going to Manila time. We're going to start promptly, so we'll just kick off. The purpose of this webinar is to increase awareness about emerging climate risks and update you on what the regulators are doing and what is happening in the boardrooms and in the courtrooms and what the risk experts are doing with all this information. So just a quick housekeeping note, given the large number of registered participants, this is a Zoom webinar format, so we won't be able to interact with all of you like a Zoom meeting. But please type in your questions in the Q&A chat box, and we will address them during the last 15 minutes of the webinar. So great, let's proceed. I am delighted to introduce you to Cathy Marsh, our head of legal for private sector operations, for her opening remarks. Cathy, the floor is yours.
Thank you, Christina. Welcome everyone to our webinar today, and thank you for joining us. I'm delighted to open this event and welcome this esteemed panel of experts to discuss emerging climate risks for companies and financial institutions. Our panelists all work at the cutting edge of advising the private sector about climate risks, opportunities, and tools in this era of climate change. Climate change, as we all know, I think, presents risks that we have not seen or experienced before, which we will all need to consider when projecting into the future. For example, we're at the early stage of understanding the physical risks of climate change, but it's already having big impacts on businesses worldwide. Which companies and assets will be impacted most, both positively and negatively, due to the worsening physical impacts of climate disruption, will need to be assessed and quantified. Liability risk has been increasing, with more litigation against companies and financial institutions around the globe, resulting in court judgments to halt or vary business operations. And the transition to a net zero carbon economy has already been impacting business operations and asset valuations. Industries will need to change their business models and practices or retool themselves in order to fit within a low carbon transition economy. Assets may lose value or even become stranded if their owners are unable to adapt to these changes. What do these climate risks mean for companies and financial institutions? What are the issues and developments to look out for? And how can these risks be best managed and integrated into businesses? Our experts will delve into this further during our webinar today. Beyond the risks, businesses recognize the opportunities associated with transitioning to a sustainable and carbon neutral world. For example, addressing physical impacts of climate change will require resilient infrastructure, assets, and supply chains, which can lead to competitive advantages. There will be new growth industries and business model innovations. Already, numerous sustainability-linked financial products and instruments have been developed, and there will undoubtedly be more to come. Companies and financial institutions play a critical role in delivering a net zero economy, which will require a massive reallocation of private capital towards greener, more sustainable activities. At the same time, multilateral banks, like the ADB, have made significant climate finance commitments. For example, ADB announced just a few days ago that, as well as our commitment that under our strategy 2030, 75% of our total operations will support climate action, our ambition is that our cumulative climate finance commitment from our own resources will reach $100 billion by 2030. We will also scale up climate finance and investments in private sector operations. This includes creating more commercially viable projects for both ADB and private investors. The expansion will be underpinned by improvements in operational efficiencies, a post-pandemic recovery in market demand for financing, new technologies, and innovations in climate finance, and new areas of business for private sector climate operations. ADB intends to support these initiatives with $12 billion in cumulative private sector climate finance from our own resources and anticipated crowding in of an additional $18 billion, giving a total of $30 billion overall. Furthermore, our Office of the General Counsel's Law and Policy Reform Programme has been providing technical assistance to modernise legal frameworks to attract greater climate finance and climate investments into our developing member countries, as well as assisting to align legal frameworks with the Paris agreements. Our LPR programme also delivers capacity building programmes to assist judiciaries in adjudicating complex environmental and climate change disputes effectively. And we work with academic institutions to integrate environment and climate change courses into their law school curricula. There is no doubt we're at the tipping point, and we need to urgently address climate change to preserve the natural environment and stable economies that we all depend on. The UN Secretary General, Antonio Guterres, described the findings of the latest report from the Intergovernmental Panel on Climate Change as code red for humanity. We must all work together towards a faster transition. It is now my pleasure to hand the floor back to Christina Pack, the head of our Law and Policy Reform Programme. Thank you, Christina.
Thank you so much, Cathy, for your insightful remarks and the call for urgent collective action. Next, we will move to a presentation by Nigel Brook. He's a partner at Clyde & Company, an international law firm, where he leads their resilience and climate risk practice. I always look forward to presentations by Nigel because I learned so much. He's a treasure trove of climate knowledge, especially on the latest litigation trends. Nigel, the floor is yours. Thanks.
Thanks, Christina. So we go straight to the next slide. Just to go over the basic science here, this first chart shows us in red, the average temperature across Earth, across land and ocean, through the last 125 years or so. And also the concentration of CO2 in the atmosphere, the continuous blue line. And what we can see here from the 1950s onwards, in particular, this really clear correlation between CO2 concentrations and average temperature. And unfortunately, the curve is bending upwards, which is why this is so urgent. This linkage here. And if we go to the next slide. So these are the fundamentals here. And this, just to make this clear, this is rock solid scientific consensus. The report that Cathy mentioned, the latest report from the IPCC, came out early August, is consensus science. Everything in this report has been pored over in detail by the world's top scientists. And so this is a kind of conservative consensus. So the concentration of gas is like a thermostat. The more CO2 we put into the atmosphere, the higher the temperature goes, the average temperature, because CO2 emissions remain in the atmosphere for hundreds of years. So this is cumulative. If we stopped tomorrow, we would be stuck at the current climate setting, so to speak. But we're nowhere near stopping yet. We're at record emissions post-pandemic. These are two quotes from this latest report. So as I say, the language now is unequivocal, expressly stated. Human influence has warmed the atmosphere, ocean and land. And that's a combination of emissions and deforestation. And then this code red that the UN Secretary General, that phrase he used, but this is the language of the scientists: adaptation and mitigation choices in the near term, and he's really talking about this decade, will affect the risks of climate change throughout the 21st century. So this is the urgency of the talks in Glasgow next month, COP26. We really have to turn this around start doing this round in this decade. So the next slide, about physical risk, just to hammer home the point that there is not just a correlation with average temperature, it's also a correlation with natural disasters. So this is a Swiss Re chart. The vertical light blue lines are man-made disasters, a number of man-made disasters per year for the last 50 years. And we can see there that there's a welcome turn downwards from 2005 onwards, but the solid blue line is the number of natural catastrophes, and that is not trending downwards, that is trending upwards in line with the temperature rise. And this is manifesting itself as more severe rain events, longer lasting droughts, heat events like we saw in USA and Canada in the summer, and so on. So these are exactly what scientists will predict. We will just get more and more of these extreme events as we put more and more heat into the atmosphere. And the next. So then there's also, though, as we transition towards net zero, and the goal is to get to net zero by the middle of this century, that's our best chance of keeping warming to no more than 1.5 degrees, though it's a really steep decline that's needed to get there. So this is a simplified illustration of some of the implications of that. So let's imagine that from some point in this decade, we bend emissions downwards. So the amount of oil and gas and coal being produced and put into the stream of commerce comes steadily downwards. And in the meantime, the challenges, the green line of renewables trends upwards, and the two lines cross at some point in this century. There's still a lot of fossil fuel incumbents who expect business as usual to an extent, that some sort of increase in demand for their products. The gap between those two represents stranded assets, and that could be manifested as oil and gas reserves that never get exploited. It could be coal-fired power plants that get shuttered years ahead of schedule. It could be internal combustion engine production lines that get closed down with a write-off there. But it's not just in the energy sector itself. There's right across the economy. The shift to net zero will be the largest industrial revolution and the fastest industrial revolution the world has ever seen. It will touch every single area. It'll touch land use as well. And all of that will have major implications. It will create winners, because there will be huge new economies growing up to make this possible. And there will be losers, the incumbents who try to stay with their existing business models will be among the losers. And this, depending on how smoothly or otherwise the transition goes, if it's a bumpy, disorderly transition, then there'll be even larger write-off of assets, sudden changes in asset values, and so on. Now, all of this, the physical risk, we're going to get anyway, because as I say, until we get to net zero, the planet will keep on warming. Plus the risks associated with the transition, the economic losses, the economic shocks that they both create will in turn drive disputes. And so if we now turn to the next slide. So LSE Grantham in London do a fantastic job of collating cases from around the world, along with the Sabin Center at Columbia Law School in New York. And they keep a grip on climate cases around the world. And they work collaboratively. And every July, the LSE comes out with an annual snapshot of litigation. So these charts we're seeing here are from that report. So the count as at May, the end of May 2021, 1,841 cases to date. That's the cumulative total, but it's accelerating. So over 1,000 of those cases have been filed since 2015. And you can see here, there's an uptick from 2007 onwards, but it is carried on here. 2021, we don't know, but we guess will be in line ultimately with the prior years as well. And just turn to the next chart. So this is again from the same report, and it shows the breakdown. This is typically what we've been seeing over the years, that North America, particularly USA, dominates. It's about 75% of the cases filed. And that's true of most kinds of litigation, not just climate litigation. It is a very litigious country, but there is litigation everywhere. Quite a lot, as we see in Asia Pacific, and increasing amounts in Europe as well, and new kinds of litigation there. About 75% of litigation is against governments, but I say 25% of that number, that's a lot of cases against corporations and individuals. So we go to the next slide. So I've just plugged out some categories of cases. There are lots of categories, and as I say, this is evolving rapidly, and we're getting new kinds of case emerge. But just to give you some highlights, there are cases against corporations trying to hold them responsible for their historic emissions. So the highest profile cases are in the USA. There's about 15 of them now against oil majors, and they're brought by municipalities and by states. So this is governments against corporations. And they're claiming billions of dollars in damages for the expenses they'll have to incur in the future. So, for example, states on the coast have to build seawalls. Denver is saying we're going to have to reinforce our fire service because there'll be increasing wildfires, something we're seeing a lot already. These cases are mired in procedural applications at the moment. There's none of them anywhere close to a trial on the merits. In the meantime, in Europe, there's a similar case brought by a Peruvian farmer called Mr. Yuya against RWE, which is Europe's largest utility, and again, claiming damages. Now, this one is actually a strategic case. The damages are nominal. This is really to make a point. But again, it's about the historic emissions of RWE and seeking to hold them responsible. If any of these cases were to succeed, then it could be apocalyptic, because of course anyone in the world who has suffered damage from from the emissions from climate change, in principle, subject to any jurisdictional limitations, could also say, I'd like a slice of that myself. So one to watch, but as I say, the US cases are some years away from a trial on the merits. Strategic cases, there's a real growth in these more generally. And now within these strategic cases, we're seeing rights-based cases. So these are cases saying that governments and corporations owe duties of care to their, in the case of governments, to their citizens, to curb emissions. So these are forward-looking cases. These aren't about historic emissions, they're about future emissions. So there's the highest profile success was against a government, against the Netherlands. The Agenda case, and that was upheld by the Supreme Court in the Netherlands end of 2019, ordering the Dutch government to make more abrupt cuts in emissions than they had planned. And they actually did that. They were given 12 months to do that, and they accomplished it largely by bringing forward the closure of coal-fired power stations. On the back of that, Milieu Défensie, which is the Friends of the Earth in Netherlands, brought a case against Royal Dutch Shell. They're headquartered in the Netherlands. They've got 1,100 operating companies around the world. And the court at first instance in May ordered Royal Dutch Shell to cut its carbon emissions by 45% by the end of this decade. And not just its own emissions from its own operations, but the emissions of its customers who purchase its product. That's under appeal, but it's had sent shockwaves around. It's already spawned litigation against VW, BMW, and Daimler Mercedes in Germany that's just started in the last few weeks. So this could open up a whole new front in litigation, but this is rights-based. This is a new duty of care inspired by the European Convention on Human Rights, among other things. So it's soft law turning into a hard law duty of care. Greenwashing in Australia, this is a new case brought by an NGO against Santos, calling them out for their claims in their latest annual report that they would get to net zero by 2050, and they sold green fuel. And they're saying you can only achieve these things by carbon capture and storage, which hasn't been proved at scale yet, and certainly isn't economical. So you're misleading investors and the wider world. And that'll be one to watch. There's a lot of this class of litigation now really kicking off, driven, of course, also by ESG, where companies are tempted to overclaim their greenness. And then there's also this category of cases against companies or individuals asserting they failed to take account of physical risk or transition risk, the impact those would have on the corporation, or the impact the corporation was having on the wider world. Perhaps the highest profile one is this case against, again in the USA, against former directors of PG&E. So they're a major utility in California. They were implicated in some of the large wildfires in 2018, in particular the Camp Fire, which is a devastating fire. Those claims that were brought against them for that destruction of property and so on brought them into bankruptcy protection. It also spawned a case against the former directors saying, you mismanaged the company. If you'd taken more aggressive steps to update equipment, make sure that the power lines wouldn't spark against each other, cutting back vegetation and so on, then this wouldn't have happened. That case, nine-figure damages being sought, is now being activated this year. So again, one to watch. But this more general idea that boards could be held responsible for failing to take account of the impact of climate change, physical risk, transition risk, on their decision making, their acquisitions, their disposals, and so on. They could be called out for this. The duties of care really are moving on in this regard because the facts are moving on. So much more is known or knowable today about climate change and its impacts than was known even 5 years ago. If directors don't keep up to date with that, then they could get into problems. One other category, just to briefly mention, is the value chain. There's more and more litigation now about failing to look into your own supply chain and work out if there's been any environmental abuses, violations in the supply chain itself. Again, this is happening in Europe. We anticipate it'll happen in other parts of the world as well. So this is increasing the duties on directors and to make sure that they have a real grip on the impact that climate risk will have on their corporation.
Thanks, Nigel, for that overview. I mean, certainly our courtrooms have been very busy, and at ADB, we're keeping track of all the climate litigation in Asia and the Pacific. But I guess, you know, your presentation shows the, you know, multidisciplinary approach that's needed. I mean, we have to understand the science, we have to keep up what's happening, you know, in terms of liability risk and just in the industry, and also risk, the various risk management tools. So, you know, so that's why we actually assembled a multidisciplinary panel. Not all lawyers. We have, you know, professionals that have been regulators, risk managers. So I think it's really will require a multidisciplinary collective approach in terms of climate risk management. So with that, you know, we'll start off our panel discussions. And so thank you, Nigel. Again, I learned so much from you, and I'm sure our audience did too. And really, thanks for giving us the latest on the litigation trends. So now we'll go to our panel discussions, and you know, we'll kick off with Dr. Nicola Ranger. She actually works in the intersection of markets and climate change. And she has extensive experience working with developing countries. And it's a real privilege to have her on our panel. So perhaps we can start, Nicola, with COP26. It's not too far away. And there's a lot of expectations on COP26. So I was thinking it might be helpful for our audience to get a global context, and in particular, what could be in store for businesses and financial institutions. So welcome, thank you.
Thank you, Christina, and thank you for the invitation, and thank you, Nigel, for the introductory presentation, which is excellent. So how do I build upon this? So my background is as a scientist originally. So I'm a climate scientist, but have spent most of my career working in climate policy in international institutions and in the British government as well. And most recently have joined the University of Oxford, where I am Deputy Director of a new institute called the Centre for Greening Finance and Investment, which is all about supporting financial institutions to manage climate environmental risks to their businesses and to investments, etc., but also to find opportunities from investing in a net zero economy. So let me give some sort of views on COP26 then. So well, I think the first thing I would say about the negotiations is, well, as a starting point, the global goal to reduce emissions in line with a 1.5 or 2 degree goal has been set. So governments around the world have agreed to this goal. This was finalized in Paris a good number of years ago. Now, where we are now in the negotiations is trying to put in place all of the different mechanisms that are needed to do that, and particularly in sort of setting the what we call the sort of enabling environment to enable finance to flow and businesses to begin to adapt towards this goal in terms of changing patterns of energy use, changing in some cases structures of economies where they're very fossil fuel dependent. So all of these things need to happen, and as Nigel laid out, it's actually it's a big challenge ahead of us, and an essential challenge. At the moment, our emissions are still increasing. They slowed down during COVID, but now they're right back onto increasing again. And so this is a really critical moment where we need to make that transition towards these goals that have been set internationally. And we don't yet have some of the international and national architectures that we need to do that. But we have seen enormous progress in recent years. So for example, at least 12 countries have net zero targets in legislation. Many more are bringing those into legislation now. We have now, I really welcome the commitment of ADB, as mentioned by Catherine, and in terms of supporting this transition. So the role of multilateral development banks is absolutely critical in providing the financing to support this transition, particularly in emerging and developing economies. We have investments in innovation. So all of the pieces are coming into place, and very, very rapidly. So I've worked in this area for 20 years, and the pace of change in the last 5 years has been quite incredible. So from COP26, and I should say that what I would expect to see, so there are 3 themes at COP26: mitigation of emissions, adaptation to the impacts that Nigel described, and finance. And I'm going to particularly focus on finance. We're already seeing a huge amount of announcements in the run-up to COP26. So I will be at Glasgow myself, and I'm wondering if actually all of the announcements are going to come before it actually happens, and what will be left to announce actually there. But you've seen, for example, a huge number of banks and asset managers committing to net zero pathways. Many billions of assets now are locked into net zero pathways, over 100 billion. There's huge momentum in this. We're seeing innovation every day. We're seeing new funds being announced, new challenges being announced, new regulatory structures being announced. Just yesterday in the UK, a new framework for sustainable investing was announced by the government. So all of these things are coming together, and what I expect from COP is to see this momentum. But I think what will be critical, though, is that we need governments to set this enabling environment, because unless we have the targets, the markets to be built, etc., it will be more costly to make the transition that we need to make. But let me just come on briefly to some of the things that are happening in the finance sector. So I think this has been a particular area of innovation and really rapid progress in the last 5 years in particular. So what we'd expect, and what I think businesses can expect going forwards globally and including in the Asian region, one is real changes in investor expectations. So, this and part of this is linked to the various litigation aspects that Nigel has laid out, but also just in general, there's a huge investor expectation that companies are responding to the need for a net zero transition. And that's reflected in what's happening on boards. It's reflected in what's happening in voting patterns of investors and actually in costs of capital as well. So research that we've done at Oxford shows that if you're trying to access lending, for example, for a higher fossil fuel dependent business, it actually costs you a lot more now than for a more sustainable business. So it's being now reflected at the core of business and in the bottom line of businesses. So that's one. The next one would be requirements on disclosure. Now we're seeing this around the world. Again, in the UK, where this year large companies have to report, so large banks, insurers are reporting for the first time. Next year, corporates are reporting for the first time on their climate change activities. In the EU, this is coming in 2022. Singapore from 2023. Hong Kong is bringing this in over the next couple of years as well. The US is bringing this in. So this massive push towards more disclosure, more transparency, more accountability over the environmental and climate impacts of businesses is happening globally. And that's again linked to investor expectations. But I think, and I was on a panel with Gavin Starks from Icebreaker One last week, who said for businesses, this is basically as easy as it's ever going to be right now. It's only going to get harder in terms of disclosures. So I think that's a really important message, that this is something that businesses around the world need to get on with really seriously looking at and putting in place the right mechanisms, because it's happening globally. But also I want to just point out then on the opportunity side. So we've talked about the risks. Nigel's talked about stranded asset risks. So this risks that if we don't, businesses are not transitioning and potentially could face much bigger risks from stranded assets over time. So that basically means reduce asset values over time. We talked about the physical risk, but I want to finish on the opportunity. This is a massive opportunity. This is, the biggest investment opportunity ever, some people say. And we see this now in terms of, the huge increase in, for example, green bonds, huge investor interest in investing in these types of businesses. 93 trillion needs to go into low carbon technologies and industries over the next decade. This is a massive, massive opportunity for business. So I think while we talk about the risks, I think we also need to recognize this huge opportunity. And I think Catherine made this point as well, this early advantage for companies, competitive advantage for companies and financial institutions in really nailing this and being ahead of the pack on this. And I'll finish there. Thanks.
Thanks, Nicola, for that broad overview. You talked a lot about, creating, what I'm hearing is the enabling environment, what is going to require to transition to net zero, and certainly finance is one of them. But I guess, the next speaker, I want to turn to Geoff, who has extensive regulatory experience as a former board member of the Australian Prudential Regulation Authority. And, he has been leading significant regulatory efforts on climate risks in Australia and globally. So, I wanted to turn to Geoff to get a sense of, what the regulators are doing in the region to address the risk and also harness pave the way for the opportunities that Nicola has pointed out. And perhaps you can also zone in on, the specific issues in the Asia Pacific region as well, with so many, with diverse and smaller economies. So I'll hand the floor over to Geoff. Thanks.
Yeah. Well, thanks, Christina, and great to be with you. And my thanks to ADB for the invitation to be at this event, and for Nigel, Cathy, and Nicola for setting the scene. So climate change is not sort of an economic scenario, it is the base case. And I think that's a really important sort of concept to get in your mind, because there's no optionality here. It is already happening, and it is accelerating, as you've heard from the previous speakers. The world is moving to net zero, and the only point of contention is the trajectory at which we are doing that. And that is going to have profound implications for every aspect of the way the world operates, not only economically, but how society functions as well. And if as a global community we move quickly, and we need to do that, this is a critical decade up to 2030, then we might just mitigate some of the most severe impacts, but the world will still look very different, even at 1.5 or 2 degrees. So let me talk a little bit about what the regulatory community is doing with that context and that background. So as Nicola has mentioned, there has been a paradigm shift in the regulatory community in the last 5 years. And that shift more recently has been from looking at inward risk to institutions, and predominantly financial institutions, to how those institutions are aligning to the transition to net zero. So the early focus was, what was the impact on this bank or this insurer or this pension fund? It is now, what are those organisations doing to support the communities they serve and their customers in the transition from a current carbon-intensive economy to a very different economy over the next decade or two. Regulators are often lag indicators, but I'm pleased that they have been very proactive in the last 5 years on this journey. But they're only one actor. Investors are important, customers, employees, activist groups, the courts, as you've heard from Nigel, and yes, of course, policymakers and regulators as well. So ambition is accelerating. I mean, here in this region, China will have their peak emissions by 2030, and with a net zero target of 2060. One hopes that that will be able to come forward in the period ahead. India, a 35% reduction on their 2005 emissions by 2030. Japan, a 46% reduction out to 2030 on 2013 emissions. South Korea, a 40% reduction. So in this region, in the Asia-Pacific region, some of the major players have made very strong and public and defining commitments. And I raise those with the 2030 target because really, actually, what happens out to 2030 is what matters. Beyond that, it's, dare I say it, too late. So global capital markets get that, and there's an expectation that TCFD aligned reporting occurs. It's already been mentioned that in some jurisdictions that's mandatory. I would expect that if not, why not? Why, to major players, why aren't you reporting against TCFD? And in some jurisdictions that is mandatory. I think that'll become the norm. But as it currently stands, where it is not mandatory, regulators are saying if you're not reporting under that framework, then you probably should be. And that is the case in many Asian jurisdictions as well. So what's happening in the regulatory community? The IMF has been very active. The BIS, the Bank of International Settlements, which is the sponsoring organisation for the Basel Committee on Banking Supervision and the International Association of Insurance Supervisors, that has also been extremely active. I mean, you cannot go to a regulatory conference anywhere or regulatory discussion anywhere today and not have climate as one of the lead issues that are being discussed. Regulators have had to come up the curve. They've had to understand what's going on, and there's been a focus on awareness, but with not only amongst the regulatory community and the skilling of the regulatory community, but that has now shifted to raising the awareness within the firms that they supervise, and increasingly issuing guidance and regulation to embed climate risk in normal business activity on how you assess risks in those firms. Of course, climate risk is very different to any other sort of risk because it's a ratcheting risk. You can't unwind it. So you can't recapitalize a bank. You can't recover the data in a data breach like you can with other sorts of risks. Climate risk is, in many cases, permanent. We don't know as yet how to cool the planet. So in jurisdictionally, again, very active in this region. The MAS in Singapore is one of the lead regulators and lead participants in these debates. The Malaysian Central Bank has also been very active. India, I know from my insurance days, and is active in this regard. So is Hong Kong and Japan, particularly around TCFD adoption. So Christina, I would say that the major shift that I'd like to point out, and particularly as it relates to the financial services sector, is that there has been this shift from inward risk to wanting firms to actually show how they are and their operations and their support for their customers are moving to a net zero future, and the trajectory of that across not only the energy sector, but the transport sector, the manufacturing sector, the food and ag sector, the built environment, infrastructure. And so, if you have a customer in any one of those sectors, whether you be an insurance company, a bank, or a pension fund, then you have to work with that customer and understand what the risks and, as Nicola has pointed out, to opportunities as we transition to a net zero future. So I'll pause there and look forward to contributing later in the discussion.
Thanks, Jeff. I mean, definitely, I think the regulators have recognized that climate risk is a systemic risk. So now it's definitely embraced, in markets and institutionally. I guess the only, the thing about disclosure, I'm just wondering, what do you think? Do you think there's a risk of fragmentation in terms of like different types of, disclosures
So one of the big issues, Christina, has been taxonomy and actually what is it you are disclosing. So TCFD has been very successful in raising firm level awareness and firm level disclosure on and providing a framework for assessing climate risk. Where it's been less successful is making market comparable disclosure between different firms and in different markets. So there isn't as yet a common set of taxonomies to measure various aspects of the risk and indeed opportunity. And there are many projects underway at a regional, sub-regional, and even, dare I say it, global level to try and put some more specificity around that. But I don't think that should be a reason. It's sort of a cart and horse debate. I don't think that should be a reason not to disclose. And in fact, I know here in Australia, where I'm joining this call from, that the conduct regulator has said that you are better to make your informed disclosure than no disclosure at all, on the basis that issues like taxonomy, specifically as it relates to climate risk, aren't finalised.
Okay, great. Thanks, Jeff. So, now we'll move on to the boardroom with Ellie. Certainly, I think even in the boardroom, there's been a sea change. So Ellie, Ellie's from the Commonwealth Climate and Law Initiative, and they've been doing some significant work on Board of Directors' duties and liabilities in relation to climate-related risks. Can you provide us with a brief overview of some of the issues? And it would also be really interesting to hear about the legal opinions on directors' obligations in climate change. The floor is yours, Ellie. Welcome. Thanks.
Thanks, Christina. And thanks to the ADB and to my fellow panelists. It's great to be here with you today. You might hear my Australian accent, but unlike Jeff, I am not in Australia. I'm based in London, so much closer to Nicola and Nigel. So Christina, you're right. At the CCLI, we spend a lot of time thinking about directors' duties and climate change. And here's the snapshot. Why is climate change a director's duties issue? Because climate impacts and the net zero transition are financial and systemic risk issues. They must be integrated into corporate risk management, corporate strategy, and disclosures. And this engages directors' governance roles because they oversee risk management and strategy, and they sign off on disclosures. And if it's not done well, directors may be personally liable through duties and disclosure claims. And what makes the potential for director liability for climate risk issues particularly prescient? Well, it's both the potential for losses of large magnitude, like those stranded asset risks Nigel was talking about earlier, and also strategic climate litigation that he mentioned. So there's a snapshot and a little bit more detail in the next few minutes. So D&O liability risks, like other climate liability risks, stem from physical and transition risks. And Nigel has talked you through some of these, and particularly accelerations in the transition risks leading to stranded assets. So back in 2019, we had a warning from 3 central bank governors. They said if some companies and industries fail to adjust to this new world, they will fail to exist. So directors must understand this new risk environment and help their companies navigate this disruption. And what if they don't? Well, here we have a growing body of legal analyses across jurisdictions, particularly published legal opinions by commercial barristers or commercial law firms who've never said a green thing in their lives, that climate specifically, or ESG generally, is a matter of directors' duties. So this started back in 2016 in Australia with the Hutley opinion. That was the first one to connect the dots between the climate science, between the financial economics, market trends and stakeholder expectations, this new risk environment and what it meant for the director's duties of care, skill and diligence. Since then, in other jurisdictions, we've had the Chapman-Tripp opinion in New Zealand, the Debevoise opinion on UK private company directors and ESG. We had them in Asia. So the CCLI has commissioned the Chan opinion in Singapore, the Devan opinion in India, and next week we'll have the Stock opinion in Hong Kong. Also drawing these together, we worked with the World Economic Forum's Climate Governance Initiative, and in June this year launched a global primer on directors' duties and disclosure obligations on climate change across 22 key jurisdictions. So what do these legal opinions say? The existing directors' duties regimes, the law as it is in the books, is conceptually capable of being applied to climate change as a financial risk and a financial opportunity. So directors' duties to act in the best interests of companies require consideration of climate issues to the extent that they intersect with the interests of company. As Nigel and Nicola and Geoff have told us, the evidence of those interests is increasingly clear. And the duty to exercise due care, skill and diligence requires a proactive and increasingly robust consideration of climate risks to fulfill the standard of care. And this is the case even in jurisdictions without express stakeholder considerations like Australia or Singapore, which compared with the UK and Canada. This is because climate is increasingly foreseeable material financial risk. But the legal opinions are unique to the jurisdiction. So if you're a director of a company in a specific jurisdiction or advising one, please do look to these legal opinions because, for example, India is the only jurisdiction in the leading economy that has a specific mention in the statute that directors have to act not just in the best interests of the company, for the company, but also for the protection of the environment. And the India opinion by Shyam Devan SC draws on this. So these opinions tell us that directors may breach their duties if they fail to take into account climate-related financial risks in their financial planning, strategy, asset valuation, risk assessment and disclosure. So on balance, the risk of liability might not be high, but as Nigel said, we are starting to see the first cases. And just how quickly is our understanding of legal duties changing? Very. And here I'll use the Hutley opinion as the example. So the first one was back in 2016, climate is a financial risk issue. Then in 2019, Mr. Hutley and Mr. Hartford Davis, the barristers, looked at the evidence again and said, well, because of these developments since 2016, this has only elevated the standard of care. This is how quickly it's moving. And then in 2021, they said the standard of care is elevated again. And they looked at a specific issue of greenwashing, concluding that it can form a unique and acute source of legal risk. It's not that directors can avoid making net zero statements. In some cases, for some directors of a company, that will be consideration of those will what be required of their duties. But in doing so, they need to avoid greenwashing. And finally, why legal opinions by independent counsel? Well, these update our understanding of the law without needing a court judgment, because directors want to know, what are my duties and how do I fulfill them? And influential stakeholders can point to these. So these include regulators such as Mr. Geoff Summerhayes that we have here today. In his role as the executive board member of Australia's prudential regulator, he regularly pointed to the Hutley opinion in his speeches, so that showing that his work as a prudential regulator on climate risk is consistent with and amplifies the requirements of corporate law. And we're seeing that happen as well. The Singapore opinion has been picked up by the Singapore Stock Exchange in their consultation paper, and their CEO has already spoken about it. So these shift our mainstream understanding of climate as a financial risk that must be incorporated into governance and disclosure so that boards can make better decisions today to avoid liability in future. I'll leave my remarks there for now. Back to you, Christina.
Christina, sorry, you're on mute.
Sorry about that. So these legal opinions, they're sort of like somewhat like industry opinions. Are they published where people can access them?
Yeah, so all of these opinions that I'm talking about today have been made publicly available.
Okay.
And then we'll also have summaries. They're all publicly available online, so we can send them through to you so that then you can have hyperlinks to them. And then they are summarized, for example, in that World Economic Forum Climate Governance Initiative primer. That's really not new analysis. It's drawing it all together. What does this mean? And how can I click through and find, here's the summary for me, and how can I find what I need to understand my duties in my jurisdiction?
I see. Do you expect them to be like updated from time to time? I know it's just at the beginning stages, but over time, is this something that will be built up over time, like like for a House of Opinions?
Well, that's what we've seen with the Australian opinion. Nicola said, this is moving so quickly. The last 5 years has just been acceleration upon acceleration. And so in Australia, the CPD that have been working on that, the Centre for Policy Development, and the instructing solicitors, Minter Ellison, have kept going back to council to say, here's some more developments. So what? So what? I think that in some jurisdictions, we will see them updated. In others, we will just see the advice being updated. So law firms can point to this as that kind of seminal legal analysis. And then from there, they will continue to look to the facts as they are changing, the risk environment, the expectations, and they'll need to update their analysis as well. So I think sometimes it will happen organically, and sometimes we'll see that people go back and ask independent counsel again for an update.
Right. There's just so much to keep up on. The board of directors, they need to get up to speed if they're not. All right, thanks, Ellie. So now I want to turn to the courtroom with Liam. So Liam is a litigation partner. Hey, Liam, at King and Wood and Mallison Sydney office. So Liam has also been on the forefront of litigation developments, and interestingly, there's been a lot of landmark cases coming out from Australia. And so I was thinking, maybe you could just give us a flavor of the types of recent litigation coming out of Australia. And then, I think climate-related disclosures is also really, really important, and especially because it's evolving. If you could maybe talk about a recent case that sort of like sheds light on this, area of greater scrutiny of climate-related disclosure. Thanks, Liam.
Thanks, Christina, and thanks to ADB for the invitation. As Christina said, my background is as a financial services and class actions litigator in Australia. So in a sense, the fact that I'm thinking and working on these issues in the way that I wouldn't have imagined I probably would have been 10 years ago is a tribute, I think, to just how rapidly climate change litigation is evolving and developing over the last few years. The case that I wanted to really touch on is one that, at the start, is one that's commenced in July last year. The O'Donnell and the Commonwealth class action commenced in Australia. It's a case that I think really sits at the intersection of the disclosure and directors' duties and strategic litigation trends that some of the other speakers have referred to. It was a case commenced on behalf of retail investors in Australian government bonds against the Australian government, the Secretary of the Australian Treasury, and the CEO of the Australian Office of Financial Management, who also have responsibility for those bond issues. The claim alleged essentially that investors in Australian government bonds face material climate-related risks, and the claims of particularises a range of those risks, and physical risks, transition risks, sovereign responses, the kind of risks that a lot of you on this call would be quite familiar with. And it alleges essentially that those risks should have been disclosed in the information memorandum, which is the document that's provided to potential investors in those bonds, and should have been disclosed to those investors so that they could take that information into account in deciding whether or not these bonds represented a good investment for them. The claim was framed at the outset in three ways. First, as a misleading and deceptive conduct claim. That's a statutory cause of action that exists in Australia across a wide range of areas, in consumer law, but also in financial services law. It was also framed as a breach of, alleged to be a breach of duty, the duty of candour and honesty, and a breach of the duty to take reasonable care and diligence, which is a statutory duty in relation to these decision makers, but it's analogous to the director's duties that Ellie referred to earlier on. The case is ongoing, and it has been mired in some of the sort of procedural issues that cases like this sometimes face, as Nigel mentioned earlier. The respondent, the Australian government, brought a strikeout application earlier this year, basically saying that the case shouldn't be allowed to proceed to trial because it wasn't sufficiently there was an adequate case to proceed. The judgment in that strikeout application was handed down about a week ago, and essentially the court accepted that the case could continue. It accepted that it could continue as a class action. The rules in Australia around class actions are quite permissive, so even though the government suggested that there wasn't really a common interest between various bondholders in these climate change issues, the court didn't accept that argument and said that it could continue as a class action. The claims in relation to directors' duties were struck out, but not on the basis that those sorts of claims couldn't be made, rather on the basis that the person who brought this claim didn't have a sufficient interest to bring them. So it was a standing issue for this particular plaintiff not having the standing to bring those claims. But importantly, the misleading and deceptive conduct claim survived, which is not to say that it will necessarily succeed at trial, but it wasn't struck out. It was allowed to continue on to a trial on those issues. In terms of what that case is telling us, I think that investor disclosures, at least in Australia, are an important future area for climate change litigation. They're the kind of the flip side of that push towards increased disclosure that a number of the other speakers have touched on. In Australia, I think it's particularly interesting because you see in this case climate change litigation, which has obviously been around for some time, moving towards the framework of investor disclosure class actions, which have themselves been an enormous area for growth in litigation in Australia over the last 20 years, and an area where there really is a great deal of depth and expertise, both among practitioners and judges. So I think it's potentially a very fertile area for those kinds of cases to develop in. It's interesting to see the development of the misleading and deceptive conduct claim as a new avenue, and one that isn't as susceptible to some of the standing issues that plaintiffs have faced in other claims that have those more rigorous standing requirements. And also interesting to see the development in the direction of class actions. The O'Donnell case established that there was no issue with seeking the sort of bare declarations and injunctions, statements of principle from the court that have been sought in O'Donnell without substantial damages claims. The government suggested that that shouldn't be possible in its response, but the court rejected that argument. So the class actions are an open avenue, at least in Australia, in that sense. And because class actions in Australia at least require approval for settlements, they're not as court approval for settlements, they're not as exposed to some of the kind of early settlement strategies that have knocked out some of the individual plaintiff actions that have been brought on similar issues, because in order to settle the class action, you need the court's approval to do that, and it brings a level of public scrutiny with that as well. Similar with the strikeout application that was brought unsuccessfully in O'Donnell, it's relatively difficult to strike out class actions because they're supervised by the court, and the court is reluctant to compared to an individual action to see that claim extinguished because it could potentially affect the rights of an entire class. At a wider level, I think the case shows you're still seeing cases that are focused primarily on trying to establish from the court symbolic or principled statements of law, and establishing the framework for future legal evaluations of these issues, and not yet seeing scrutiny of those principles and the disclosure issues being targeted towards actually obtaining substantial damages awards. That's not something that's being sought in O'Donnell, but more that sort of still seeking to set up the frameworks for future cases. Pause there.
I mean, these types of misleading and deceptive type of claims are prevalent in many securities laws around the world, and
yeah.
It's interesting about the class action suits because they're not as easily dismissible. I'm just curious in terms of like issuers disclosure requirements under Australia. Is there like uniform type of requirements for financial issuers, and would having in place TCF adopting like TCFD framework help mitigate maybe some of the litigation risk, because there would be some sort of some standard of what should be in disclosures?
Yes, I mean, there certainly are quite detailed frameworks for financial disclosure generally in Australia, and you're increasingly seeing regulators and accounting organisations, people who are responsible for those standards, sort of beginning to engage with, or continuing to engage with, how climate risk issues can and should be incorporated into those. In terms of, does consistency in those frameworks reduce litigation risk? I think it certainly has the potential to reduce that risk. I think if everybody knows and agrees on what the expectations are, and there's a lot of detail and consistency around that, it's easier for corporations and other disclosing entities not to sort of accidentally fall short on those expectations. And at the same time, the sort of increased regulatory buy-in around these issues that Geoff has spoken to means if you build that sort of increased regulatory guidance, it helps companies understand more clearly where the expectations are. I think the standardized frameworks also help build the sort of the expertise in the market. A lot of this reporting is very detailed and complicated for companies, and you need that kind of pool of expertise. And I think to help people do it well, and I think consistency helps build that pool of expertise. I think all of that leads towards, yes, it does make it easier for companies to not fall short, to not end up publishing misleading statements or greenwashing statements, those kinds of things. I think at a specific level, it does have the potential to make litigation easier in some senses as well, in particular cases for companies who fall short. I think in the O'Donnell case that we were talking about, one of the strikeout criticisms was the generality of the risks that supposedly were not disclosed and should have been disclosed. I think clearer frameworks will make it more possible to precisely articulate in those kinds of cases exactly what is missing from those kind of disclosure documents. And so in a sense, the adoption of clearer frameworks might also make it more challenging for companies that fall short, and easier for litigants who want to criticize those shortcomings.
Seems monumental. I think Geoff said something, I don't know if it was you, Geoff, that said also it needs to be tailored for different types of industries. So I would think that what's material and what needs to be disclosed for different types of industries and sectors would also be challenging. But I guess this is like a whole nother, it could be a whole nother webinar, but it's very topical. So, I just want to now circle back with Nicola, and, she's worked a lot in ADB's region, particularly in the Southeast Asian region. And I'm hoping, actually I just wanted to get an idea of what are the particular climate risks in the South Asia region? And I guess also, how do you assess and quantify these types of risks? So it'd be great to hear from you on that. Thanks.
Thank you. And are you able to bring up the slides that I shared? Thank you. So I think one of the key challenges at the moment is around how you actually assess these risks that we've been talking about, the transition risks, the physical risks, and the liability risks. And I'll also mention nature as well, because nature and environmental impacts and risks are, I would say, sort of next on the horizon in terms of focus. So there's a huge amount of innovation happening in this area on providing risk information, particularly to firms and to financial institutions, to help them to provide the disclosures that we've been talking about, but also to think about how they can align their activities with net zero goals or adaptation goals or nature-related goals. So I just wanted to sort of share an area that we've been particularly focused on. So we have, being based at a university, everything that we do is open and in the public domain. We've had a particular focus on filling one of the key gaps, which is if you're a big financial institution or a big investor, usually you are dealing with thousands of companies all over the world. And one of the biggest issues is trying to get information about all of those individual companies that you may be investing in or lending to. And in some cases, you don't even know where all of the different operations are, because you might be investing in one company, and then underneath that, there's a series of other companies. So actually getting that information is a real challenge, and that will improve as these disclosure requirements come in. But particularly if you're a big multinational bank or a big investor, it's a real challenge. So one of the things that we do is using satellite data and artificial intelligence and all sorts of techniques like this to develop understandings of where are all of the assets globally and what environmental impact are they having. And this is something that we call spatial finance. If you go to the next slide, so I've just got a couple of examples of some work. If you go to the next slide, please. Next slide, please. It's stuck. Anyway, I'll keep talking. If you can change the slides, please do so. So if you go to the next one as well. So what we do is actually identify, based on satellite data, where these assets are and their characteristics. And we do a lot of this work actually in the South Asia and Southeast Asia region, but also globally. I'm going to just talk very briefly, if you go to the next slide, about some work that we've done on particularly high carbon sectors. So we've done a huge amount of work recently on energy production, cement, steel, and iron manufacturing. And all of this information is in the public domain. So I encourage you to have a look at it. Basically providing a mega database of where all of the facilities are globally, who owns them, what their emissions are, that can be used if you're a financial institution or even a firm to very quickly get a sense of what actually are the risks to your company, but also the impact that your company is having on the environment, as Geoff laid out. If you go to a next couple of slides, so the next one, sorry. And one of the types of analysis we do is looking at this stranded asset issue. So we can look at, okay, these are all of the assets in a particular country. This is the pathway that we need to get onto to achieve, say, a 1.5 degree temperature constraint goal globally. How are those assets in a particular country or owned by a particular company? aligned with that path, and where could you see the risks? And what this shows, so this is actually showing a result for China and looking at steel assets in China. So this is basically mapping all of the steel assets in China in red, and the line down the middle is basically those that would be consistent with a 1.5 degree goal in terms of our global emissions. And this shows that almost 35% of steel producing assets in China are not compatible with a 1.5 degree goal. So that, represents a particular stranded asset risk potentially for the country and for investors that are investing in those assets. So this is the type of data analysis is becoming available. This is something that we do at Oxford, but there are a large number of producers globally, both proprietary information, but also open information as we provide. If you go to the next slide, please. So this just shows a map of particularly sort of country level. So in terms of the fossil fuel producing assets, which countries are least aligned with a 1.5 degree goal? And you can also do this, as I said, for companies as well. If you go to the next slide. And then, sorry, go up. And then just finally, so we've had a particular focus on the Southeast Asia region. One, because there's a large number of higher carbon assets in the region. Actually, if you've seen that list, it's actually not one of the worst regions in the world, but certainly an area where stranded asset risk is a real risk. Also, physical risk is very high in Southeast Asia, as you'll know from being based, many of you based in the region, very high exposure to flooding, to tropical cyclones. One of the key focus for us is on understanding the systemic risk associated with that. So not just damage to your individual property or your individual asset, but the systemic risk to the economies of those countries due to climate-related physical risk. And then finally, this just shows a mapping, building towards understanding the nature impacts, which I said is one of the next things on the horizon, I think, in terms of regulation. Looking here at different fossil fuel producing assets, so steel producing plants, for example, and their proximity to areas of threatened species. So potentially sort of an indicator of the biodiversity impact of assets. So this is the sort of information that's now becoming available to support firms and financial institutions to be both disclosing their risks, but also and their impacts, and also thinking about how they can align with global targets. And I'll finish there. Thank you.
Thank you. Is this like scenario analysis? Is this what's called scenario analysis that different companies can do or countries do on a countrywide level?
Yes, some of it. So the scenario analysis is, for example, what I showed about the alignment with a 1.5 degree goal. So that is showing, okay, if the world as it is moving towards trying to achieve a 1.5 degree temperature goal, so that's the scenario. What's then the impact on different high fossil fuel using firms? And you can identify based on that which ones are really at risk of having stranded assets, damage to their asset values as a result of that, from potentially having to close early, reduce their production, etc. So that's, as Ellie laid out, that's a key financial risk to firms operating in the region and globally.
And this type of information would have to be disclosed.
Yeah.
Okay, got it. So on that note, maybe we'll turn back to Liam. Go back into the courtroom. I guess we've heard a lot about different types of cases and different ways companies and financial institutions could be dragged to court. Are there any common themes which would subject companies and financial institutions to climate-related litigation? Would you be able to draw some stuff out, like if their entity, obviously, if you're like fossil fuel would be of great risk?
Yeah, I think there definitely are obviously operations that themselves create direct climate risks. Tend to be a focus for people considering these kinds of actions. It's particularly where those operations that create climate risks require some form of administrative decision or license. That has been a particular sort of focus for litigation, at least historically, because those decisions in Australia and a lot of other jurisdictions are subject to judicial review. And historically, that judicial review context has been one of the sort of easier legal avenues in which it's been possible to bring in evidence on climate change kind of issues to argue that those factors are relevant in the exercise of effectively of a public power, and therefore of judicial review of that public power to decide whether someone should be able to be granted a license to operate a coal mine or whatever it is. Recently in Australia, you see the Sharma case is a good example of the way those kinds of cases continue to develop, where you see the court find that there is a duty of care to avoid personal injury to future children, but also finding in that duty needs to be considered in the context of exercising a statutory power to decide whether to approve a coal mine. So that's certainly one well-established area of exposure. Increasingly, you see exposure just around prominence, whether you're the largest emitter who's likely to attract attention just from the communities that are exposed to those emissions, or on the basis of particular harms. But increasingly, putting aside the question of people who are the companies who are actually sort of directly involved with things that sort of are increasing climate risks, simply being a company with a large investor or customer base is increasingly a source of exposure, because it increases the pool of people who have standing to bring a claim for some of the sort of new, more emerging areas of climate change litigation risk. So things around the sort of scrutiny of disclosure that we already talked about in the O'Donnell case, and the access to public records cases, sorry, not public records, access to company records cases that we've also seen in Australia against the REST superannuation fund and the Commonwealth Bank. And so those are sort of, that's a sort of another emerging area where just the sheer size of some organisations' public profile increasingly exposes them to those kinds of risks.
I see. Thanks, Liam. Nigel, I was actually, since you're also an expert on climate litigation, would you be able to comment on some of the common attributes, or how, other types of litigation like the, Royal Dutch Shell case could be, maybe could inspire other types of litigation in other jurisdictions? But maybe, what are the common attributes that would increase litigation for a company or FI or for an industry?
Yeah, well, Royal Dutch Shell is certainly a really striking decision. You look at the factors that the judge took into account in that case, and I mentioned human rights, Articles 2 and 8 of the European Convention on Human Rights, the right to life and the right to family life were the main ones. But there's also a 2011 UN compact, and it's directed at businesses, and it hadn't really got much attention, I think, at the company level. It's been around for 10 years, but it is now starting to inspire laws as well. So we've got various laws in Europe and a directive coming just around the corner about value chains and having to carry out due diligence into them. That is directly based on this 2011 soft law from the UN. And the UN body itself is looking to firm it up now, that we may be getting something in the next few months on that. So I think that, of course, will be something that operates around the world if it gets firmed up at the UN level. But I do see this beginning to spread. There's this idea that companies do owe duties, that it's well established that governments owe duties to their citizens. This idea that companies owe duties to the citizens of the country in which they operate is quite a novel one, but I can see this getting some traction. Very early days. This is a first instance decision, one first instance decision in the Netherlands, but as I say, it's already inspiring other litigation against heavy emitters. So it's a particular category of litigation against the high emissions sector, and so very much one to watch.
Yeah, it's great that we have webinars like this to really, build awareness and get a heads up and really know what's happening. I think it's important for, companies and financial institutions get up to speed on their, the risks. Yeah. So I think this is a good segue to turn back to Ellie. So, I mean, what I'm hearing is that, good governance in the boardroom can definitely help manage the risks. So I'm just wondering what good governance looks like, and do you see companies kind of getting up to speed on good governance, good climate governance? Thanks.
Sure, Christina. So are companies getting up to speed? Yes and no. We are on this virtuous circle of learning by doing, but many are still not doing enough or are operating under misapprehensions that if they do something, they're leaving profit on the table, and they can't do that. And even those well-advised boards are grappling with the pace of change. So we've got new information, new practices and tools, new expectations from investors like Paris-aligned accounts. So even the leaders can't rest on their laurels. You asked me, what does good governance look like? Well, it's very hard to give specific examples of good governance for two reasons. The first is that governance processes are notoriously opaque, and that's by design. We don't know what happens in the boardroom. We sometimes see outcomes of board decisions like final investment decisions on new projects, but we don't know whether they've undergone that robust assessment against climate risks. So do projects have built-in optionality for further emissions reductions technologies? Have revenue streams been tested against the introduction of Paris-aligned carbon prices or technological developments like green hydrogen? We just don't know. The other reason is, thanks to the TCFD, we have a lot of companies disclosing their governance processes for climate risks. But even with those descriptions, we don't know whether these are working, both downstream and upstream. So are these policies and processes being actually implemented by the business? We also, going back up, we don't know, is relevant information flowing back up to the board in order for them to fulfill their duty to oversee that risk management process as well. So it's hard to give good examples, but we do know what it looks like. The unique characteristics of climate change mean that existing systems may no longer provide that kind of optional foundation for effective governance. But this doesn't mean that climate governance should sit outside those existing structures. To the contrary, it should be wholly embedded and integrated into them. So we need to consider existing risk frameworks and then update them to make sure that they continue to provide in light of the breadth, depth, and magnitude of climate risks. So these frameworks can draw on things not just like the TCFD, but also we've got updated guidance. Like we've got updated guidance from COSO and the WBCSD on how the COSO 2017 risk management framework applies to ESG risks and climate risks specifically. We've also got updated guidance from the accounting standard setters on how existing accounting principles apply to, how climate risks apply to existing accounting principles. So from there, good governance, we know it means that we need to do that risk management. We also need to do that corporate strategy as well and build that around the value opportunities that Nicola mentioned earlier, to develop and implement credible pathways to net zero emissions operations or portfolios, to consider those climate risks in M&A due diligence and financing, and also across contractual suites and supply chains. So here I talk to boards about 4 things. So the governance accountability, to make sure that boards are educated on climate risks, to make sure that they inquire of management and advisors, to make sure that they critically examine strategy, risk management and disclosures for materially relevant climate risks, and then explain all of this in their disclosures. And here I'd like to just point to a few different organizations that are doing capacity building for directors and boards. So we're in the midst of the great upskilling. We understand that climate is no longer this environmental or ethical issue. So too other nature-related risks, like the species risks that Nicola was mentioning. So we have some groups that are helping to upskill directors individually. The CCLI works with experts like the Oxford Sustainable Finance Program and the Oxford Sustainable Law Program. Another group we collaborate with is the World Economic Forum's Climate Governance Initiative, that have these peer networks of directors in a bunch of different jurisdictions that are upskilling. And I know that like Nigel Brook and Clyde & Co work with those peer networks, like Chapter Zero in the UK and France. Malaysia was one of the first peer networks. So we have all of this director support. We also have some groups upskilling boards as a whole, and here I'd like to mention Earth on Board. That's led by Philippe Jobert. He's a former Alstom executive and a special envoy on energy to the WBCSD. But even for those kind of capacity building for boards, it cannot all be left to subject matter experts. Like your legal, commercial, financial, and accounting and technical advisors can and must give good climate integrated advice. So sometimes you will need a climate scientist like Nicola, but sometimes you also need, sometimes all the time, you need your legal advisors to be climate savvy, climate aware, like we're hearing from Nigel and Liam today. Back to you, Christina.
Thanks, Ellie. I mean, it's certainly great to have a wide network of people working in different things. And it's great that we have all of you. So we're drawing to the end, and I think, you know, there's just been so much, but perhaps we could turn back to Jeff and really talk about, you know, the opportunities in transition to net zero. And, you know, in your opinion, Jeff, do you think growth is possible in net zero economy?
Well, completely. I mean, we are about to enter, we are in the midst of, I should say, the largest sort of economic transformation in human history. You know, it is akin to combining the Industrial Revolution and the digital revolution together. And you know what? If we don't do that, we're in a lot of trouble. So there is a huge existential incentive for that to occur, and I have every confidence it will. I work with a climate advisory and investment firm called Pollination, which has operations throughout the globe, including here in Asia. And we are seeing the smart money moving very fast. So there's been a lot of talk tonight about the risks, but the opportunities are enormous, as a couple of the other speakers have referenced. And they're enormous with existing customer bases. They're enormous with untapped market opportunities. They're enormous with emerging technologies and new companies. And again, we've heard a couple of those examples. And Christina, I might just finish by saying that one of our largest clients is an Asian-based conglomerate which has operations across many sectors of the economy. And going back a couple of years, they had no net zero target as an organisation. They now have that embedded across all their major divisions, and the trickle effect of that down to changing their strategy, their business model, their organisational structure, their company narrative, and brand positioning is incredible in a short period of time. And this is a many hundreds of billions of dollars organisation, and so this is happening and happening very quickly. And so my message to all of those on the call, don't miss the opportunity here. Risk, of course, is important, but we see firms not doing enough in the opportunity sector of this incredible industrial transformation that is happening, and it is happening quickly. And and some of that is opaque to people, but companies, directors, executives need to get informed, need to understand, need to look at what the smart money is doing, and need to align around what will be a critical decade out to 2030. Thanks, Christina.
Thanks, Jeff, for that inspirational last message, because, I think with risks, it's just a very scary period, transitional time for corporates and FIs just wading through this massive amount of change. But I think maybe we should have a whole seminar on the opportunities looking ahead. I'm looking at the time. There's just not that much time for Q&A. Maybe Bryony can, I think there's one question, Bryony, did you get an opportunity to see that?
I did, and I've put a response in the box. I think so. The question for everyone's benefit is, why has it taken so long for so many companies and directors to change, when this comes against the backdrop of having the UNFCCC in 1992, decisions from the New South Wales Land and Environment Court in 2007, holding that climate change was a deadly serious issue. And I think what the speakers today have really demonstrated is that it's really comes down to a combination of factors, things like needing the climate science to be clear. So the IPCC has the science is getting better and better. Technology is enabling better understanding about the climate science. There's also better awareness about the attribution science. So being able to connect climate change with catastrophic events. Also, regulatory frameworks haven't been there historically to either prod or enable change. So these are really critical. Unless directors either understand the need for change and the risks that are there, or the regulatory framework changes around them, there's little incentive for them to change how they do business. And I think these factors are really critical for bringing companies on board. But as we've also heard, the new operating environment means that companies and businesses either adapt or they go extinct. So I think those are my final comments. Christina, thank you.
It sounds daunting, Bryony.
Sorry.
So this basically concludes our webinar, but I think no matter what happens at COP26, the role of businesses and financial institutions, it's critical, because they play a huge role in helping to build resilience against climate change and protecting our natural capital. So congratulations and well done to our excellent panel. All of you are just amazing. So we really appreciate you, joining us and sharing your knowledge. And we really hope next time we can host you at ADB in person, because it would be great to have a follow-on session, just because I know that, even next year, there's just going to be even more developments to report on. So I just want to congratulate all of you and thank you for your valuable time, and also to our audience for tuning in. So this concludes our webinar. So thank you so much.